Dziękuję, że panowie znaleźli czas, żeby nas odwiedzić.
Thank you very much for finding the time to visit us.
Katarynę, bo ja jej nie znam, ale jak Państwo znacie, to przekażcie jej, że pojawiłem się, bo się...
Kataryna jest na sali.
Można zakładać, że się nie pojawi.
Kataryna jest na sali.
Well, yes, Katarina is here with us. She would like to send her our best
Jak Państwo
regards.
wiecie,
As you know,
w ubiegłą sobotę
last Saturday
w Azerbejdżanie
in Azerbaijan,
aresztowano Emina Mili.
Emin Lamidi was arrested.
Dla niego miejsce.
We left a spot, a seat empty for him. We also printed out a conference ID badge for him, and as organizers we asked the representatives of our government what can we do as citizens and how could the government help us, because it does seem that the participation in a peaceful demonstration to support the freedom of speech and the freedom of gathering well is a privilege of a democratic state of law. What can we expect from the government? Well, there are two questions. What can a civic society do, and what can we expect from the government? You probably do understand that the possibilities of government operations are limited, and we have to be much more cautious, but we also know that the Ministry of Foreign Affairs is now monitoring the matter, and nevertheless the matter itself definitely triggers concern. Now, with regard to the social scale of the matter, you are the best person to respond to that, because you are a master of organizing different social protest campaigns, and I believe that you could probably tell me what we could do. So I understand that if we file a petition in order for the government to actually support us with diplomatic channels or otherwise, or if we file a petition with members of parliament, then we can definitely count on the government to help us. Well, the government is different to the parliament. The parliament, or actually the same, the lower house of our parliament, has more to say. After having talked to our members of parliament, after having talked to members of my own club, parliamentary club, I concluded that some actually believe, some are quite open in responding to the matter. Well, I would like to move to the main motive of our conversation. At the Ministry of Justice, we have many lawyers. I had, when preparing for this conversation, when preparing for this conversation, for this panel, I was wondering, how do Ministry of Justice officials know or learn what is the law like? Well, that is a very interesting question, but also I believe that they should be aware of problems of the judiciary and the penitentiary system. For the past 2 years, actually, some areas of law are no longer subject to the Minister of Justice, and the Ministry of Justice has to resolve those matters by acting on the organizational and administrative side. At the Ministry of Justice, the problem of contacting practitioners
od dawna w sposób, którego chyba nie da się zastosować w żadnym innym.
I do believe that the Ministry of Justice, you have to understand, has many judges who have been employed at the ministry at the motion of the minister. We understand that those are practitioners that are trying to monitor the matter. Well, this is my question. Where do they know what the law is like? Because whenever we attend training session for purposes of online conferences, we were told that an official from one of the ministries told us that this system is not what he would imagine it to be, because it should be connected to the official database of information concerning the law. But he was very surprised to learn that such a system does not exist in Poland. We would like to hence learn how those officials know where the law comes from. Possibly they should be buying commercial software on the open market to tell them what the law is like. Maybe this is the solution. I'll be open and frank with you. I am not interested what the source of their knowledge about law is. They are to apply that knowledge in order to be able to work at the ministry. And I must say that not being a lawyer, to the extent to which I can assess the competency of the ministry officials and the judges at the ministry, the competency in terms of their knowledge of legislation, well, it's not bad, but I understand that some people could indeed be found to be not fully competent. Nevertheless, I do believe that overall the competencies at the ministry are sufficient. A much more broad problem is totally different, the knowledge of the reality at different levels. It is not only the problem of officials or judges working at the ministry, because they usually alienate themselves very quickly from whatever is going on in the real world. For example, whenever the discussion focusing on digitization begins. But I do believe that there is another problem here. The vast majority of judges are individuals who are mostly working as judges, and judgeship is their fundamental occupation. I believe that all of us here could quote examples of the lack of knowledge of the market economy reality, which is exactly why I can see my advisor here, Minister Jarosław, we have decided to change the curriculum for at the schools training judges in order to expand their knowledge of the reality. I should probably hand over to Minister Hawadej. Actually, you defined that problem, I hope, when defining the Better Regulation 2015 governmental program. I understand that you have identified the problem. I agree with it, but I would like to ask how you approach the matter. Well, I believe, as Minister Gowin told you, that the lack of knowledge of law is not a problem, because we do have the knowledge is sufficient. We have the official journal, we have the official monitors. Each and every lawyer working on an act of law has that, has those acts of law on his or her computer. We have the Minister Berek, who filed a draft to actually discuss the process of making law. Nevertheless, I do believe that the knowledge of reality may indeed be a problem. The knowledge of reality and the knowledge of the effect of reality, and the knowledge of the reality as it is affected by any legislation passed, and I do believe that herein the challenge lies. This also ties in what had been introduced at the Ministry of Economy in 2009, which shall now be rolled out throughout the government. Post-legislative assessment monitoring system. The point is that in case of the Ministry of Economy, actually the business people are the main source of our knowledge. It is the business persons who tell us where the reality might or might not be affected by new legislative provisions, and they also are a source of knowledge as to when the law might become outdated and stop matching the reality. And thirdly, when it comes to the economic side of law and the knowledge of the effects of having sound knowledge of the law or not, well, having joined forces with our ministers, we have actually managed to transform training sessions organized by the head of the civil service, organized by our officials. And this is when it comes to the actual nitty-gritty of the matter. The point is that our officials ought to be aware of the reality and of the legislation planned and of the effects of all law passed. Well, I do believe that were I not to ask the question, probably my audience would consider me incompetent. Most recently, we have been told about a number of courts which had been shut down for a variety of reasons. But I wish to remind you that we did have a case of the Constitutional Court ruling that the Parliament cannot cancel or null any legislation passed, i.e. this means that judges may not be aware of the fact that a specific legal provision had been cancelled several hours before. The Ombudsman had been telling us and the society that administrative law is chaotic. I understand that if you decided to create that system, you had to begin with defining the issue as a problem, and that is what matters to me. Is that only an initiative of the Ministry of Economy, or is that a broader definition of the or initiative of the entire government? Well, I do not wish to say that this is the first time that we have done it, but we have already managed to overcome the silo structure of work concerning a variety of drafts, legislative drafts. And I must say that Minister Hawade is himself a person who has who credit should go to, because he had been the author of a variety of initiatives of cooperating with the Ministry of Justice when it comes to regulations, for example, regardless whether they had been authored by the Ministry of Justice or the Ministry of Economy. All drafts are co-designed by experts, by specialists from both ministries, and I do believe that the Bankruptcy Act is the best example here. We are now approaching the final stage of the Act of Law, which shall change the philosophy of that law. I believe that each and every business entity deserves a second chance, a second opportunity. The point of the Bankruptcy Act is no longer to get rid of a person who is going through temporary trouble. I do believe that we have just last week drafted the final version, the final release of the Deregulation Act. I believe that this is a very valuable document. We have joined forces with the Ministry of Economy and the Governmental Legislative Centre, and we have joined forces in order to engage in broader cooperation in the area of deregulation, and that does not only apply to free access to a variety of professions. The Ministry of Justice has filed an initiative to pass a systemic deregulation act, i.e. we are interested in the introduction of solutions which shall ultimately protect us against excess regulation, against the passing of redundant legislation, not to mention the fact that we shall also be focusing on quality of regulation, of regulations of new legal provisions. Such is the position of the Ministry of Justice, and we are now waiting to learn the positions of other ministries and the Prime Minister. We do believe that certain solutions ought to take on a statutory form. In other words, it is not only about a set of best practices, it is about a self-regulating act of law. This is something that we would like to pass. We also believe that in the process of passing law, in Poland at least, the most important thing of all is to improve the stage of actually passing a decision whether a given act of law is to be passed at all or not. Today, the department directors are really and truly empowered. Mr. Gowin had written in his book that tells us that the minister should know department directors rather than higher-ranking officials, and that is very true. At the law-passing stage, we shall be working with committees to be established at all ministries. Those committees shall be advisory committees with a membership of representatives of employers, of NGOs, and so on and so forth. Those advisory committees shall be charged with the task of answering the question whether there is the need to pass an act of law or not. Minister, don't you believe that social consultation is to be fulfilling that role? Social consultation is indeed important, but usually social consultations take place at a stage of a decision having already been passed whether an act of law shall be enacted or not. The only question that remains to be answered is what kind of form and shape such regulation is to take on. We do believe that the social factor, the control factor, should at the stage of asking whether a given act of law is necessary or not. In the United States, citizens and organizations had required the government to secure matters for the so-called Star of Death, and the government responded that they do not have no such intent. And that was true. Why finance a solution that may actually be demolished by a single individual on board of a spaceship? But at least the society was responded to, or there was a response given to the society. I would also, and a required number of people have to sign such a petition. In Poland, if a citizen sends in an application or a motion, files a motion with the central administration, it may turn out that the central government or the administration will lose that document. Minister, you can definitely expect that the civic legislative forum actually filed such a letter, such a motion with you, because we are interested in the actual legislative process. So probably it would be worth your while responding. My question is, how can us as citizens count on specific solutions? The Ministry of Justice had actually launched an initiative of reviewing all rulings, and that is very valuable. The Ministry of Economy shall be shortly launching a social consultation portal. That's all in fine and dandy, but that is not sufficient. I, as a citizen, am asking the question, what kind of right do I have to use such tools? Have you ever considered the question, what is going to happen once the government changes, once the term of office of our parliament is shortened, theoretically speaking? How then we as citizens ought to protect ourselves? How do we secure secure such a right for ourselves, because today we do have social consultations at the governmental level, but it is only the Council of Ministers who actually exercise that right, whereas you have to understand that the law is there, but the citizens are not really empowered. Right. Shall we go back to the Death Star? No, not really. Well, we have adopted the Better Regulation Program. We managed to adopt it because a variety of ministries can actually become involved. The Government Legislation Centre and the Chancellery of the Prime Minister had joined forces with the Minister of Justice, not to mention the Ministry of Administration and Digitization. Thanks to that joint effort, we have come up with a document which I do believe contains, for the first time in our history, a comprehensive image. But that is not yet a binding law. No, it is not, but as the Minister had said, certain works are in progress at the Ministry of Justice, and contrary to common belief, those actions are not counterproductive or not mutually exclusive, because, well, that project includes works which cannot really be all made part of the currently binding law. That would require certain organizational solutions. One would be hard-pressed to make all these decisions part of an actual law. Nevertheless, the advantage of that document is that of setting up a specific culture at the administrative level within central administration in order to prepare sound criticism of what is going on and to organize post-legislative monitoring activities, not to mention appropriate consultation exercises and evolutions when drafting the act of law. On the other hand, we also assume that the other side shall be exercising their rights. Well, I wish to remind you that you are citizens as well, so we are not necessarily on two sides of the river here. The official, a public official, is also a human being and a citizen. Without certain habits or activities kicking in, well, we cannot rely on legislation alone, which ultimately means that this internal activity, such external activity of the government, allows to set out requirements for the highest possible quality of law, but it also provides us with an array of tools in order to improve the quality of any legislation passed. And I do believe that this is a sound basis for permanent changes to be made part of the central administration. Could you please give us an example? Well, at the Ministry of Economy, we have had certain experience. In 2009, when we passed our first regulation monitoring ordinance, it was considered to be an intrusion. Well, some people don't want to be part of it. Well, when we passed the Official Form Standardization Act, the purpose of which was to standardize several dozen official documents, well, then ministries or representatives of ministries attended all consultation sessions, and everyone started with the following comment that, yes, we are in favor, but in case of our ministry that will not be possible.
Mamy ustawę na przykład z konsultacjami publicznymi o związkach zawodowych.
We have had a draft act of law, drafts Trade Unions Act. Solidarity have been aware of what we are doing, and that certain trade unions
działań,
provisions of that
właśnie
act
też w taki
are not
sposób,
adhered
że,
to.
wpuszcza się pewne przyzwyczajenia w
So,
jakiejkolwiek administracji. Moim
certain
zdaniem
habits
mogą
are made part of the central administration, and such habits, quote unquote, may support future efficiency of any act of law. With regard to habits, I believe that all of us here could agree that access to public information, access to information about how the state operates is of paramount importance to how democracy operates. Well, once you begin talking about our officials' habits, let me tell you the following. The president of the State Foundation had caused the Supreme Administrative Court to pass two rulings. Nevertheless, that stemmed from the fact that the senior president of the Supreme Court had actually lost to the senior president of the Supreme Administrative Court, and that is quite interesting. All of us following the course of matters have become interested in a letter filed with the Supreme Administrative Court. Well, and it proves that the senior president of the Supreme Court is actually afraid of facing charges of having committed a crime. The senior president of the Supreme Court may claim that the right of access to public information should not be recognized as public information. Nevertheless, I do believe that you will agree with me if we ask whether the right of access to public information should be recognized as public information. Well, most recently, I am of high opinion of positions taken by the Supreme Administrative Court and the Supreme Court. I believe that in this particular case, the president of the Supreme Administrative Court had been in the right. Nevertheless, we are doing a number of we are taking a number of activities in order to improve the system. By the end of the year, we are going to change the reality of local courts to a certain extent as well. How much will that cost us? Well, we know the exact number. We know the precise number. Okay, so could you please provide that information to us, not in private conversation, but in the public domain? We are very precise in calculating all costs concerned. We launched the rulings portal. We do believe that the duty of making rulings public stems directly from the Constitution, which is exactly why we do believe that the rulings portal ought to be recognized as a foundation of any court being public. By January the 31st, this portal had received 1.2 million hits, but I do believe that this system has been quite successful. But let me this rosy picture to a certain extent. Not everything is as beautiful as it seems. Anonymization is a factor.
And here we've created a set of specific rules. Judges have different opinions on this portal. Now, part of the community, part of the judges believed that the rules on anonymity were too tough. We had a debate with Paweł Dobrowolski from the Forum for Civic Development to the effect that rulings ought not to be made anonymous. We believe that owing for the protection of the dignity of people, they need to be made anonymous. But you will admit that if an administrative court makes the ruling anonymous, so that we read in a ruling that this ruling applies to Minister Michael B., well then obviously there will be a ruling on failure to provide public information by the Prime Minister, who will be referred to only by his initial. But public figures are less covered by privacy. We introduced fairly specific, detailed rules on anonymity. It's done automatically. If we were to do it manually in courts, it might lead to undermine access to justice, which is another fundamental human right, because the courts would then be paralyzed. But this bitter pill, if you will, should all information be made available to the people. Some say that people abuse freedom of information. I say no, because access to information is something required not just by citizens, but also by lobbyists. Let me give you a specific example from the end of the last term of Parliament, when there was a lobbyist who was representing a huge foreign corporation, applied under an FOI to the Prime Minister's office for information regarding the negotiation guidelines or assumptions of the state of Poland on economic matters. And the raison d'etat and its common sense required that we turn him down. Only the most fanatical adherents of freedom of information would challenge a state's right to maintain some sort of secrecy. Of course, you can introduce classification, you can classify information, make some information confidential. I suppose this will be the subject of a later debate, but to comment on your positions, I would like to end this round, this part of this panel, by asking what next? What plans do you have? I assume that you're able to say what you have in store for us in the weeks and months to come as regards the subject of this conference, personal democracy. So after the government adopted the e-regulation program, we have the hardest, most difficult stage, namely the implementation, and that's the challenge facing us, and not just us. Because it's a government-wide program, all the ministries will have their work cut out, and since we designed the program in such a way that it contains specific tasks saying who's responsible for what and by when, deadlines are given. So there are 30 items, but I won't mention them. Just to give you one example, in the near future or shortly, we will be launching a platform for e-consultation. Deputy Prime Minister Piotr and the heads of the Ministry of the Economy implemented this as a pilot project at the Ministry of the Economy. So in February, this month, we will have this application up and running, and we encourage you, but you have to post something there, of course, yes. We will, of course, announce the launch of the platform, but it's also a bilateral obligation, if you will, because we are making the instrument available, we're giving the tools, and now we're counting on feedback to the administration regarding specific projects. So this will only be at the Ministry of the Economy. Will other ministries join in the project? Yes, that's likely. We're trying to borrow best practice from other ministries, the Ministry of the Economy, Administration and Digitization. We had a talk with the director on how the Ministry of Justice could apply these best practices, the practices that will be presented, I'm sure, by the director. I'm at a loss to answer your question, in a sense, because the Ministry of Justice is working on a great deal of projects that have to do directly with individual freedoms, human rights, human dignity, personal dignity, and everything that happens at the interface between the citizen and the state. I get the impression that we have a very oppressive state. We have a very oppressive state. Just one example of something that I'd like to change. I believe that it's far too easy today to take away custody of a child and send that child to a foster home based on economic considerations. So if a family is poor, they can be stripped of custody. Even so, if a family is not well-to-do, if a family is poor, and if besides everything's fine in a family, courts can take away custody. And we want to come up with solutions that would stop that from happening. On the legislative process, I mentioned the project that is currently being worked on. This systemic auto deregulation will be implemented as a pilot project at the Ministry of Justice, and if it works, we'll propose that the entire government adopt it. Thank you very much, gentlemen. And I'd like to I hope that all of us will soon see what consultation looks like in practice as part of this pilot project. I understand that there will be some troubleshooting involved because the system is not perfect yet, obviously, so we will tweak it. And now we'll continue with our discussion on the role of the state and the role of citizens, of people, because we said a lot about the legislative process, but that's because we asked how citizens can take part in this process, and that's the last comment I would have before I let you go. I didn't want to say this, but recently online somebody wrote that if 460 members of parliament can do what they want do what they're doing with a population of 40 million, then the 40 million should be able to give them a taste of their own medicine, to respond without waiting for an election. I don't know whether that person had legal action in mind. So it's not that 460 members of parliament did something to a population of 40 million. This 460 deputies represent the people, the nation. They represent the 20 million voters, well, maybe a dozen million, 12 million active citizens who voted. And I have a lot of reservations. I'm not entirely happy with the way the Polish parliament operates, but if anybody says that the lower chamber, is not entitled to decide, then that's contempt for democracy, because you can think what you like about us as individuals, but whether you like it or not, we are the elected representatives of the nation, and we are, like the nation, with all its faults. So, right, thank you very much.
Dziękuję.